Go ahead.
Your Honor, these allegations are false. The victim has came forward and said that she lied. Your Honor,
all right, I'll
she
see
is
Mr.
my
Fipps here by
fiance.
3 o'clock today.
She is my
Who's that with you,
fiance,
Mr.
Your
Fipps?
Honor.
Who's that with you, Mr. Phipps?
This is
who's over to the side of your camera? Who's
Jasmine, my wife, my soon-to-be wife, Your Honor. That's why I needed to talk.
I said what I said. You're to be in this court in person for your arraignment by 3:30 this afternoon. And your attorney can appear via Zoom. Call your lawyer. I'll see you by 3:30.
Good morning to you and your staff. Jonathan Jones, 52920, appearing on behalf of with Mr. Fipps. Thank you for letting us do this remotely. Obviously, we consent. To the arraignment, Your Honor, I'm going to acknowledge receipt of the general waive his formal reading and send a mute.
All right, I'm a little concerned about these allegations and the fact that Mr. Fipps doesn't, I mean, he's not in custody, but he's going to have some significant bond conditions.
Excuse me?
Michael, be quiet, please. Judge, if I may, I understand where you're coming from, but I want you to know as an officer of the court that the complainant has reached out to me independently. I'm going to leave it at that. He has not had any contact with her. He will not have any contact with her. I want the record to reflect that the court scheduled this. We're grateful. We're here. He's absolutely not a flight risk, and the conditions of no contact have been respected and will remain in that manner.
Jonathan.
Yeah.
Michael,
No,
please
I mean,
do not speak.
Mr. Fipps, it's my, listen, you have an attorney. If you want to say something to the court, you're free to do so, but you have a right to remain silent. You have a right to have counsel. So is there something you need to say?
Yes, there is something. Yes,
okay,
there is something that I need to say.
Good, tell me.
Well, I would like to talk to my attorney real quick because evidently he's not aware of anything.
Oh, he's not aware of anything. All right, you know what? You need to be here in person today. You have until the end of the day.
Your Honor.
Judge, I can't.
You in person at the 23rd District Court, in person by the end of the day. I can put you two in a breakout room. You're coming in person. I'll see you in a little while.
Judge, I cannot be there in person. I'm scheduled
Your
for
Honor.
1 o'clock, and today is the Jewish holiday. I cannot be there in person.
Why can't
Well,
you
your
call
client
me?
can.
Well, that's fine, Your Honor, but I'm not going to be able to be here with him. I'd like to get him arraigned now. He and I can speak.
No, I want him here. He is charged with a home invasion first degree.
Your Honor, can I speak,
He is
please?
charged with a home invasion first degree. He is charged with.
Your Honor, can I please speak?
I'm not, do you hear me talking?
Yes,
he is charged with a 20-year felony. He is charged with assault with intent to do great bodily harm, less than murder or by strangulation. He is charged with domestic violence. He is charged as a 4th habitual offender. He has multiple prior assaultive convictions. I want him here in person. I said what I said. I said what I said. Make it happen.
Your Honor, can I speak, please?
You have until 3:30 to turn yourself into the court.
Your Honor, can I please speak, please? Please say something, please.
Go ahead.
Your Honor, these allegations are false. The victim has came forward and said that she lied. Your Honor,
all right, I'll
she
see
is
Mr.
my
Fipps here by
fiance.
3 o'clock today.
She is my
Who's that with you,
fiance,
Mr.
Your
Fipps?
Honor.
Who's that with you, Mr. Phipps?
This is
who's over to the side of your camera? Who's
Jasmine, my wife, my soon-to-be wife, Your Honor. That's why I needed to talk.
I said what I said. You're to be in this court in person for your arraignment by 3:30 this afternoon. And your attorney can appear via Zoom. Call your lawyer. I'll see you by 3:30. Oh, Mr. Verdute, you're here to cause some trouble, I see. This is 250941, the People versus Jessica Glask, Jazerski. All right, go ahead, counsel.
James Gazicki on behalf of Mrs. Jazerski. I just received the file today, and she's gone over her rights. There's no question regarding her rights, but we're requesting a hearing in this matter. I'm asking the court for an adjournment so I can review the file and be brought up to date in this matter.
All right, well, where you should start is you should ask Ms. Wagaman to play you the audio of a call that was submitted to her where Ms. Wagaman contacted the defendant about not having any contact yet again with the complaining witness. And she hung up with him and then immediately called the complaining witness and had a phone call based on her call with Aaron. That might be a good, I'll adjourn it, Mr. Gizicki. I'm just telling you that way. You don't have to go into it too much. You could just listen to that call. She has a no contact order. How many times do I have to tell you that? How many times?
I understand you.
No, you don't understand. Because no, and what did I tell you? What did I tell you when he calls you? What did I say?
You know.
And what'd you do? Instead, talk. You are not supposed to be talking to him by my court order. And this is the second time I've seen you. And the last time I said, this is ridiculous. Don't cry now. Last time I said, this is ridiculous because he's contacting her and these two are going back and forth. And then I counseled you and said, do not respond to him. If you respond to him, I'm going to put you in jail. There's no contact. And you can't listen. I mean, you can't. And Mr. Verduke, don't think you're cute because I'll see you next week on a violation. Am I seeing him this week?
No, he'll be here next week.
He'll be here next week. You two are toxic. And this is what's irritating me. You're wasting time on the criminal justice system's time on whatever you two have going on between you. You're wasting the time of the courts. You're using the criminal justice system. Mr. Verduke, I'm looking at you. You're using the criminal justice system to deal with your two little petty problems. That's what you're doing. And I'm tired of it. And what's becoming clear to me is that maybe probation's not suitable for either of you on your cases. And maybe it'd be best if you just do your jail time and we get this over with, because I am not going to play this game. I'm not going to ask Ms. Wagaman to play this game for much longer. This is it. So we'll set it for a hearing. Mr. Verduke, I assume you'll be recording when she calls you after this hearing. Make sure that Ms. Wagaman gets that, because if you call him in between now and your hearing, you have any contact with him whatsoever, I want to be clear. I am revoking your probation and I am locking you up for 90 days. One time. Do you understand me?
I understand.
Are you sure?
I'm sure.
One time. If she gets one thing that is from right now at this moment, at what time is it? 3:57, Monday, September 22nd to next week when we have your hearing, bring your toothbrush and wear a sports bra because you're going to jail. Got it?
Got it.
All right, we'll set it for a hearing. And Mr. Verduke, your violation, you better come in person. Don't show up on Zoom.
What unfolded in this courtroom was a masterclass in judicial authority and a stark reminder that no contact orders are not suggestions. The case of Mr. Fipps opened the session with immediate tension, facing serious charges: home invasion in the first degree, assault with intent to do great bodily harm, domestic violence, and being labeled a fourth habitual offender. Fipps appeared via Zoom, attempting to dismiss the allegations by claiming the victim recanted and was, in fact, his fiancée, but the judge wasn't moved. With the alleged victim literally visible on camera beside him, the court saw in real time exactly what kind of situation this was. The judge's response was firm and final. Appear in person by 3:30. No exceptions. Then came the case of Jessica Glass, and the courtroom temperature rose even further. A no-contact order was already in place. The defendant had already been warned, and yet the phone calls kept happening. The judge revealed that probation officer Wagaman had audio proof Glass had called the complaining witness immediately after being instructed not to. This wasn't a first offense. This was a pattern. The judge's frustration boiled over into a moment of raw, unfiltered truth. These two parties were weaponizing the criminal justice system for personal drama. The warning couldn't have been clearer. One contact between now and the next hearing. And Glass walks in with 90 days revoked probation. Bring your toothbrush. This is what happens when court orders are treated like guidelines. The system has limits, and judges have memories. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.